Good morning to everyone watching from where you are today. As per the introduction, my name is Peter Doughman. I'm a Senior Associate at Matthews Folbigg Lawyers in Parramatta, and I'm the Senior Lawyer of the Matthews Folbigg Workplace Solutions and Employment Law team. And as I said, as per the introduction, it's my great pleasure to be talking to you today about the new Closing Loopholes reform to the Fair Work Act, what all employers and businesses must know. There's a lot to cover today, so I'm going to try and do it within the hour, but I also want to do it in a way that does justice to each of the subjects I'm going to be covering. I'm not going to cover all of the reforms, simply because we'll be here all day and everyone else has other things to do for the day. But I'll start off by giving an overview of what the closing loophole reforms are, and then I'll cover 5 main areas, what I think are the most juicy and certainly the most relevant to the largest number of employees in relation to the reforms. They are the right to disconnect, which I think is the one that gets most of the attention, and certainly most of the questions I get asked about the right to disconnect. Then I'll go to the new test for casual employment, and following on from that, leading on from that, there are the new rights and obligations associated with casual employees. They'll be touching on the new definition of employees and how that helps distinguish between employees versus independent contractors. There's a new test, which is actually snapping back from the earlier test from several years ago. And I'll close off with the new same job, same pay protections that relate to labour hire employees. Then I'll try and tie everything up together with the remaining time, summarising what employers need to do about these changes or the reforms. So let's start with an overview. In summary, when we're referring to the closing loopholes reforms, we're referring to a piece of legislation called the Fair Work Legislation Amendment Closing Loopholes Bill from 2023. That was introduced into Parliament on September 2023. And because of the scope of the legislation, and certainly it's one of the largest amendments to the Fair Work Act since introduction in 2009, and because of the significant political capital required to pass it, the government faced some significant pressure or significant resistance from the crossbench and the Greens and the Teals. So ultimately, a deal was struck on the 7th of December to split the bill into 2 parts. The first tranche, which is described as the No. 1 Act, was passed on that same day. And the second tranche, known as the No. 2 Act, passed on the 12th of February. That was following a public comment, invitation for public comment and referral to various Senate committees for determination. So it's important to know what changes were introduced by each of the various acts, the No. 1 Act and the No. 2 Act. I prepared this graphic to hopefully show what changes relate to which piece of legislation. You'll see for the No. 1 Act, there's the same job, same pay reforms. There are increased discrimination protections. There are further work health and safety protections. There's a new small business redundancy exception. And there's also workplace delegate rights changes and the new criminalisation of wage and super theft. Now, with the No. 2 Act, they again build on those workplace delegate rights and criminalisation of wage and super theft, but they now add the new right to disconnect for employees, further enterprise bargaining changes. There's a new test for casual employment, which then leads on to the new casual employee choice pathway, which I'll discuss today. And there's also a new definition of employee, which gives rise to new employee-like worker protections and sham contracting changes. So apart from the fact it's important to know what the changes are, it's also important to know when they're going to take effect. And I have, this is a timeline which I've taken from the Fair Work Ombudsman's website, which shows essentially from the date of the passage of the legislation, the No. 1 Act in 2023, what part of the reforms come into force and at what time. You'll see that there are some that came into force on the 15th of December when the legislation was passed, or 7 days after the legislation was passed. Then there's the majority of it passed in 2024. You'll see that there's some changes to be coming into effect on 1 July. Most of the ones we'll be discussing today will be coming into effect on the 26th of August. On the 26th of August, either in relation to the new employee definition and the changes to casual employment. And there are some that won't come into effect until next year. The one we'll be looking at today in 2025 is the new right to disconnect rules that apply for small business employers. That applies all the way over in 26 August 2025. So let's start with a new employee right to disconnect. What is that? I imagine that most people generally know what it involves, but it's important to see the definition up close and really analyse what the definition of the right to disconnect is. Put simply, it's the right of an employee to reasonably refuse contact by the employer outside of their working hours. Now, that means in practice that the employee has a positive right to refuse to monitor, read or respond to contact or attempted contact from the employer or a third party related to their work outside of the ordinary working hours of the employee, unless the refusal is unreasonable. That little tag at the end is important because it really places the onus on proving whether the refusal was unreasonable on the employer. And that onus will be relevant for both disciplinary proceedings and potentially unfair dismissal claims. So, for example, if an employee refuses to monitor, read or respond to contact, it's up to the employer to prove that that refusal was unreasonable before taking any disciplinary action, and indeed potentially dismissing the employee for that refusal, because they have to prove that the refusal was unreasonable. The employee has no work to do in relation to that test. You'll see that the test relates to the reasonableness of the refusal. Whether an employee's refusal to be contacted is reasonable or not will depend on all the relevant factors and circumstances applying to the situation, including, firstly, the reason for the contact and the timing of the contact. By way of example, it's unlikely to be reasonable for an employee to monitor and respond to contact when that contact could be, or that dealing between the employer and the employee could be dealt with easily on the next working day, or indeed if it relates to work to be conducted on the next working day. It's also relevant whether the employee is compensated for being available outside their ordinary working hours, or for working additional hours outside their ordinary hours if and when it's requested. This one I think is important and an easy one for employers to deal with, because when it comes to employees employees paid by way of an annual salary, so senior employees paid by way of annual salary, you typically have terms in that contract dealing with the annual salary covering all work, both inside and outside the ordinary hours of work. So that can be dealt with quite easily with amendments to the terms of those employees' contracts. The next consideration is the nature of the employer's industry. You'll find that it will be more relevant in industries such as the medical profession, the nursing profession, the legal profession, so legal assistants, as well as industries such as manufacturing, particularly when an employer has a 24/7 manufacturing roster arrangement, or in the case of hospitality or fast food, where there's a significant number of casual employees who need to be contacted to replace staff on shifts when they're away, when there's illnesses or sickness or absence. It's also relevant to consider the nature of the employee's role and their level of responsibility. Arguably, it'd be less reasonable to require a more junior employee to be contacted or respond to contact as opposed to a more senior employee. It's also relevant to consider the consequences of the refusal for both the employer and other third parties. The consequences are not so much relevant for the employee, but more for the employer and parties relating to the employer, for example, patients in the medical industry, or residents for the aged care industry. And finally, it's relevant, the employee's personal circumstances are also relevant, including any applicable family and carer responsibilities. So when there's a dispute over an employee's obligation to respond to contact, or whether the employee considers the contact to be unreasonable, this will often result in disputes and potential disciplinary issues. So fortunately for employers, the Fair Work Commission is not a toothless tiger when it comes to the new rights to disconnect, and it provides both employees and employers may apply to the Fair Work Commission to deal with disputes over the right to disconnect. They do that by way of seeking and making an application for what's called a stop order. In the case of employees, they may apply to the Fair Work Commission for an order to stop unreasonable contact or disciplinary action resulting from a reasonable refusal to respond to the contact. And similarly, employers may apply to the Fair Work Commission for an order specifying that an employee's refusal to be contacted is unreasonable. In other words, requiring the employee to respond to future contact on the basis that the obligation to do so is reasonable. Before any of the parties apply to the Fair Work Commission, there is a requirement that the parties attempt to resolve the matter internally through their own internal procedures. So if there's a dispute resolution procedure, a policy that the employer may have in place, that would be required to be followed. And there may be obligations to comply with a relevant dispute procedure in an applicable modern award or enterprise agreement. Now, if an application is made, the Fair Work Commission does have a wide range of powers available to it. It can conduct conciliations and mediations. It can make a recommendation or express an opinion. And if and only if the parties agree, they can proceed to resolve the matter through a binding arbitration where any orders made, i.e. a stop order, is legally binding on the party to which it applies. Now, the stop order the Fair Work Commission may make include, firstly, that an order that the employee be prevented from continuing to refuse to monitor, read or respond to the contact. An order that the employer be prevented from making unreasonable contact with the employee, and that also applies to individuals employed by the employer, for example, senior managers. And an order that the employer be prevented from taking disciplinary action against the employee for a reasonable refusal. So there is inbuilt into the stop order powers essentially a restraint or an injunctive power. Now, if an application is made, the Fair Work Commission must deal with them promptly. The reforms require that the Fair Work Commission must start to deal with the application for any stop order within 14 days of receiving the application and must attempt to resolve the matter as quickly as possible based on the circumstance of the case and whether the parties require arbitration or not. Finally, it's worth mentioning that the right to disconnect is a protected attribute under Part 3.1 of the Fair Work Act, which means that the making of an application or even the threatening to make an application is a workplace right. And any employer that subjects an employee to adverse action, whether it's demotion, alteration of terms, discrimination or dismissal because of the making of an application for a stop order or because they have refused to respond to what they consider to be unreasonable contact outside their working hours, prima facie gives rise to a potential general protections claim. So the right to disconnect regime will commence on the 26th of August for all non-small business employers. So we have 2 months from today to be ready for it. For those small business employers, you have an extra year. You have 26th August 2025 before the provisions apply and your employees are able to begin to exercise those rights. It's also important to know that by the 26th of August 2024, all modern awards will be amended and varied to contain a right to disconnect term, and each of those awards will presumably have the term tailored to the industry or the profession and explain how the right to disconnect will apply in practice. So again, you'll see that most commonly or most likely in the legal service profession, the medical profession, aged care profession, manufacturing, or hospitality and fast food. So moving on, I'm going to be looking at the new test for casual employment, which has been a moving feast over the last few years, ever since a series of cases in 2020 and 2021 known as the WorkPack decisions. That's WorkPack and Scheme and WorkPack and Rosato. So firstly, I thought it'd be helpful to look at the current definition of casual employment in the Fair Work Act, and this applies right now, albeit not for much longer. And the Act currently provides that an employee is a casual employee of an employer only if, and that reference to only is important, an offer of employment made by the employer to the person is made on the basis the employer makes no firm advance commitment to continuing and indefinite work according to agreed pattern of work for the person, and the person accepts the offer on that basis, and the person becomes an employee as a result of that acceptance. You'll see in that first dot point, that's quite a mouthful in terms of the definition, dealing with no firm advance commitment, continuing to do definite work, agreed pattern of work. So it is a somewhat convoluted definition. However, in my view, the main criteria or characteristic of the current definition is it relates to an offer of employment being made and accepted. I think that's the main takeaway, is that the current definition relates to the offer being one of casual employment and that offer of casual employment being accepted. The new definition, which will come into force shortly, provides an employee is a casual employee of an employer if there is no firm advanced commitment to continuing indefinite work, and the employee is entitled to receive a casual loading or a specific casual rate of pay. That's either under a modern or water enterprise agreement or in accordance with the contract of employment. Now, you'll see here from the new definition that it removes reference to the offer and acceptance of casual employment. It removes a reference to the document, basically, or the agreement itself. It also removes reference to the agreed pattern of work. However, it's retained in a different form when it comes to the test for determining continuing and indefinite work. So there is a variation of it. It's hard to see from those two definitions how it will work in practice. However, it really comes down to this. Where there's a firm advanced commitment to continuing and indefinite work will depend on consideration of the real substance, practical reality, and true nature of the relationship. And that essentially is a long-winded and legalistic way of saying that it depends on all the circumstances of the relationship. And the factors for considering that will be whether or not the employee has a regular pattern of work or they're ad hoc, whether the employer can offer or not offer work to the employee, whether the employee can accept or reject work offered by the employer, whether it's reasonably likely that continuing work of the kind performed by the employee will be available in the future. And that one's relevant for whether the employee, potentially relevant for the test, whether a casual employee is an ad hoc casual or a regular systematic casual employee. And that difference has relevance to unfair dismissal laws. And finally, it's relevant as to whether the employer has full-time or part-time employees performing the same kind of work that casual employee would perform. So in other words, is there someone who's the odd man out, the odd person out as a casual as compared to all the other employees doing the same work on a permanent basis? So the new definition reverses the statutory test adopted of the WorkPack decisions. And by way of a very brief summary, the WorkPack decisions provided that an employee was casual if the employee accepted casual employment, accepted employment that was characterised as casual, or if the employee understood employment was casual. In other words, it looked at the document. And if the parties are sophisticated enough to understand that the employment relationship was casual, then that's good enough for the courts. The new definition snaps back to the previous interpretation, which is the substance rather than form approach, which is analysis of all the characteristics of the employment relationship, not just the terms of the employment contract itself. So we're going back to the more uncertain assessment of all the relevant factors of the relationship rather than simply what does the document say. So we've had in other words, employers have had a good run. If you've issued a contract to an employee that says they're casual, that's a relevant consideration, but it's no longer, once these new reforms come in or the new definition comes in, that won't be primarily determinative. So as to that commencement date, the new casual employment definition takes effect on the 26th of August, 2024. The good news for employers is that the definition doesn't automatically change things. It doesn't result in any deeming change of employees who were previously casual to automatically transfer them to permanent employment. In other words, employees who are casual employees prior to the commencement of the new definition are continuing to be casual employees on and after commencement. There's no automatic change to their status as casuals. And more importantly, employees who have commenced employment as a casual prior to the new definitions or are deemed to be casual prior to the definitions will remain casual until a relevant specified event. So there's no, this transitional provision doesn't have an end date. It doesn't transfer or transition deemed casuals over to permanent employment based on the new definition over a period of time. In other words, it requires a specified event before the relationship changes from casual to permanent. Specified event could be conversion to permanent employment by the new employee choice pathway, which I'll discuss in a short time. Could be a specified event could include the change of the status pursuant to either a modern or water enterprise agreement or as an order of the Fair Work Commission. Now, touching very briefly on the modern award, modern awards have the casual employment transfer, the transmission rules. They will actually be replaced by the employee choice pathway. So the old rules will no longer apply after the 26th of August. Finally, the specified event could include where the employee accepts an offer of permanent employment and commences the role, which is obviously the most practical and most likely outcome, where you decide with an employer decides with an employee that we want to transition to casual. From casual to permanent, and here's a new employment contract that gives effect to that. Now, leading on from that, I think it's important to look at what the new rights and obligations are for casual employees, because there are a few new tricks and traps. Now, most employers will hopefully be aware that there has been in existence for the last few years a casual employment information statement. Current requirement is that the casual employers are only required to issue the casual employment information statement to their casual employees before or as soon as practicable after the casual employment starts. Now, the new reforms expand on the obligation to issue the information statement to casuals by way of a series of checkpoints or deadlines. So that under the new reforms, employers are required to issue the information statement as soon as possible. Firstly, after the employee starts employment as casual employee, then 6 months after the employee starts as casual employee. So that's at commencement and then 6 months after commencement. You'll see from this table that applies both to regular employers and small business employers. Now, for non-small business employers, the obligation continues that after 12 months, they again have to issue the casual employment information statement, and then every 12-month anniversary thereafter. Now, put a pin, when you look at that table, just put a pin in the fact that there's no requirement to issue the casual information statement at 12 months for small businesses, because I think that's a bit of an issue given what is another obligation for casual employees, which we'll discuss in a moment. And that is essentially the new employee choice pathway. Now, the new employee choice pathway replaces the old casual conversion scheme that was under in the Fair Work Act and relevant awards. And it essentially moves the onus or shifts the onus on the casual conversion from the employers to the employees, which is good. I think it's an appropriate change. In essence, it provides the ability for a casual employee to issue a written notification to an employer that they would like to change their status to part-time or full-time employment from casual, where, firstly, the employee believes their employment no longer constitutes casual employment, where the employee is not currently in dispute with the employer regarding their status. So in other words, there's no dispute currently on foot. The employee has been employed for at least 6 months, or in the case of small businesses, 12 months. And in the 6-month period before the notification date, the employee has not received a response from the employer which rejects the previous notification, and the employee has not been in dispute with the employer which has resolved about the casual conversion. Now, just shifting back to the third dot point, you'll see that it requires, there's a requirement that the employee has been employed for 6 months or 12 months for small business employees. That flies in the face of what we just discussed a moment ago, which is that the employer, a small business employer, is not obliged to provide the casual employment information statement to casual employees at 12 months or thereafter. So in other words, a small business employer will issue the casual employment information statement only at the commencement of employment and then at 6 months. But an employee of a small business employer cannot request conversion until 12 months. So there's a 6-month gap between the provision of the information statement and the request that a small business casual employee can make. And you also see from the last dot point that it prohibits an employee from making a notification or issuing a notification for 6 months after they were rejected for a previous notification. So there's essentially a lockout process, a lockout period of 6 months, that if a request has been made in the past and that request was denied, they're locked out from issuing another one for a 6-month period, which I think is a reasonable requirement. If all those criteria on the last slide have been complied with and they're all applicable, and a notification has been issued by the casual employee to transfer to permanent employment, then these are the obligations on the employer to respond. Firstly, the response must be made in writing to any employee notification within 21 days. Before responding, the employer must consult with the employee about the notification, and I presume that the consultation obligations that are set out in applicable modern awards or enterprise agreements would apply also to this process. Now, if the employer decides to accept the notification, i.e. to agree to change the employee from casual to permanent, the employer must discuss the terms of acceptance, for example, whether the employee will change to part-time or full-time employment, and practically and obviously the date that that change will take effect. When it comes to whether the employee will change from part-time to full-time employment, that will mostly come down to the hours of work that the casual employee works and whether those hours are reasonably consistent and regular. For example, if the casual employee is very much an ad hoc casual employee, any change, if agreed, will be presumably to part-time. Whereas if there's a casual employee working regular and systematic hours at or above 38 hours per week, the presumption is they will transition to full-time employment. However, if an employer decides not to accept the notification, the employer must provide reasons in writing. For example, the employee still satisfies the new definition, not the old definition of casual employee, or that there are fair and reasonable operation grounds for not accepting the notification. Now, fair and reasonable is another, we see the fair and reasonable test pop up quite a few times in this Act and certainly in the reforms. So what does that mean? What does fair and reasonable operational grounds mean? Well, it relates to all the circumstances of the case, but it includes specifically where substantial changes would be required in the way in which work in the employer's enterprise is organised, or where there would be a significant impact on the operation of the employer's enterprise by pure virtue of the change from casual to permanent, or where substantial change to the employee's terms and conditions would be reasonably necessary to ensure the employer does not contravene the terms of a Fair Work instrument, for example, an enterprise agreement or modern award, that would apply to the employee as either a full-time or part-time employee. To be honest, I'm struggling with how that would apply in practice. In my view, where an employer complies with the modern award enterprise agreement in respect of the terms and conditions of a casual employee, presumably it shouldn't be too difficult and too onerous for that employer to comply with that same industrial instrument when transferring from casual to permanent employment. However, it would depend on the circumstances. There may reasonably be some circumstances where it would be difficult or onerous, depending on the nature of the industry or the way in which the employer's enterprise is set up. Now, the other obligations that arise from the employee choice pathway, these are reasonably straightforward. Firstly, employers must not reduce or vary employees' hours of work or even terminate employees' employment in order to avoid these obligations under the employee choice pathway. For example, it would be unlawful for an employer to reduce a regular and systematic casual employee's hours from around 38 hours down to 20 in the lead up to their entitlement to request permanent employment through the notification process, leading up to the 6-month anniversary of their employment when they can first start making that application or issue the notification. Similarly, the right exercised by the employees under the employee choice pathway are workplace rights for the purposes of Part 3.1 of Fair Work Act, in other words, the general protections. That means that if an employee, if a casual employee issues a notification requesting change from casual to permanent employment, that is the exercise of a workplace right, and any adverse action, whether changing hours of work, whether demoting, injuring the employee in their employment or altering their position to their prejudice, discriminating against the employee, or even terminating their employment, would be prima facie a breach of the general protections and give rise to an adverse action general protections claim. Finally, it's important to note that nothing in the employee choice pathway requires an employee to change from full-time to part-time employment. And similarly, nothing requires or permits an employer to require an employee to change to full-time or part-time employment. Whereas the prior provisions in the Act and in the relevant modern awards presumes a change from casual to full-time after a particular period of time. The new employee choice essentially allows the employee to remain as a casual if they so choose for as long as they wish. And finally, nothing in the employee choice pathway requires an employer to increase an employee's working hours who gives a notification, or even after they commence work as a permanent, if that's agreed to between the parties. So again, these new obligations, like the casual employment definition, these new obligations take effect on the 26th of August 2024. As I mentioned, the new employee choice pathway will replace the former casual conversion provisions of the Fair Work Act and relevant London awards. And that means, happily, that employers will no longer be obliged to offer employees conversion from casual to permanent after this date. In other words, the onus of the employer to offer casual conversion ceases to exist for the employer after that date, which I think is a positive development. Let's shift gear from casual employment to the never-ending dispute between whether a person is an employee or independent contractor. As most employers will be aware, this is an often fraught and often disputed area of industrial relations, where you can often find that a person who is engaged on the documents as an independent contractor or a consultant who performs work during a period of engagement, after that engagement ends, will then come back and allege that they were in fact an employee for the relevant period of the engagement and claim entitlements and benefits that are applicable only to employees, such as unpaid annual leave, potentially long service leave, notice of termination, and even redundancy. And redundancy is one that pops up quite often. Obviously, there's no redundancy entitlement for independent contractors, but if an independent contractor ceases to be engaged as a consequence of effectively a redundancy event, you often see these disputes arising in that sort of particular case. So let's cover off what the new changes are. So the Closing Loopholes reforms introduce a new ordinary meaning definition of employer and employee as opposed to independent contractor. So the definition only relates to what an employee is, doesn't define an independent contractor. But implicit in the definition is anything that falls outside the definition would presumably be an independent contractor. And the definition provides generally that whether an individual is an employee of a person within the ordinary meaning of that expression, or whether a person is employer of an individual within the ordinary meaning of that expression, is determined by ascertaining the real substance, practical reality, and true nature of the relationship between the individual and the person. So again, we're seeing the language of real substance, practical reality, and true nature of the relationship arising again in this particular test. But it also uses the language of the ordinary meaning. Now, in this particular case, ordinary meaning means arising from the common law or determined by the courts. And there have been a host of cases that have dealt with whether individuals are employees or contractors. And typically, that dispute requires an assessment of all the relevant factors and indicia of the relationship. And that can include, as you'll see on this slide, relevant consideration of the following: whether the employer or the principal can exercise control or the extent of the right to control or the individual concerned, whether the individual is provided with tools or equipment, whether the individual can choose if and when to perform work, and presumably the argument is that for independent contractors they can choose if and when to work, whereas employees are contractually bound to work when the employer requires, subject to considerations for casuals. Another relevant consideration is provision of or requirement to wear uniforms. That's not determinative. You can often find consultants that have stationery, signatures, business cards, but uniforms is a different thing, in my view, that is more characteristic of employment relationships. Whether the individual is permitted to delegate or subcontract work, and obviously there's no contractual right to do that for an employment relationship. Whether an individual is paid a wage or a salary, or whether they're paid following the completion of a particular task or project. And there again, there is a potential carve-outs for that. There can be employment for particular seasons or particular projects. You'll find them often for people working in the farming and like the fruit picking industry. So that can often be one that can be vague from time to time. But if someone's engaged for a particular task or project and they're engaged prima facie as an independent contractor, it's more likely that that will be the true nature of the relationship. Whereas someone's paid for their labour and paid, whether it's weekly or fortnightly or monthly, a consistent wage or salary. And finally, it's relevant but not determinative what the express terms of the contract between the parties say. If the contract says that the parties are engaged, or the person is engaged as an independent contractor, that will be a relevant factor, but not if all the other criteria and conditions slant the other way. The new commencement date for the new definition, again, on the 26th of August 2024. So employers and principals have 2 months to get ready for this new potential change. Unfortunately, there's no deeming provision the way we saw in the new casual employee definition. So essentially, any person who is engaged as a independent contractor prior to 26th of August may thereafter make an argument they were, in fact, an employee. And here are the potential consequences for that. Obviously, it increases the uncertainty for business as to the true nature of their relationship between what they consider their independent contractors, particularly given that these relationships can be quite diverse in their form. You can have consultants, you can have contractors, you can have people paid via the labour, you can have people paid upon the completion of a project. So there is an increased degree of uncertainty about all of this. Obviously, it will increase the likelihood of claims by independent contractors who then assert they are employees. That was what I was mentioning at the start of this section, that it's often the case that after the conclusion of an engagement, a person who was presumptively engaged as an independent contractor comes back and alleges they were in fact an employee and then makes a claim for those entitlements. And it obviously requires that businesses now need to review both their independent contractor contracts, their agreements, and consider and review the nature of the engagements to ensure that the contracts and the conditions are not suggestive of an employment relationship. In addition to the new definition, there's now an introduction to a new opt-out regime. This has already commenced, interestingly enough. It commenced on 27 February 2024, and I'm not sure why it commenced so early, considering that it relates to it applies what is the new contractor high income threshold, which, as of preparing these notes as of yesterday, I still haven't been able to find whether it's been announced what this new threshold is. Hopefully, it'll be introduced by the 1 July, and certainly by 26 August 2024, when the new definition comes into place. It comes into force. Anyway, the opt-out regime provides that if a person engaged as a contractor would likely be characterised as an employee as per the new definition, they can elect to opt out. They can elect to opt out of coverage under the definition. In other words, they can say, I don't wish for the new definition to apply to me. I'm happy to be characterised as an independent contractor, and I'm not going to be making any claims to the contrary moving forward. But for a person to be eligible to opt out, that person, i.e. the contractor, must A, be earning over the new contractor high income threshold, which everyone's now referring to as the CHIT, and the contractor must issue the opt-out notice to the employer, noting that they are above the contractor high income threshold. Now, there is a restriction on contractors only being able to issue an opt-out notice once during the relationship. Presumably, if the relationship ends and then restarts, presumably they can issue another opt-out notice if they've already done so during the initial relationship. But for each specific engagement, the contractor can only issue an opt-out notice once, and the contractor can revoke it with an appropriate amount of notice. And unless and until they do, the opt-out notice will remain in place. Finally, I want to touch very quickly on the new unfair contracts regime, which also commenced on the 26th of August. For those who are aware of the legislation, it's very similar to the way the Independent Contractors Act applies and operates. And that's another piece of federal legislation that requires any claims to be made in the federal court, the Federal Circuit Court. And those sort of claims are difficult, they're expensive, there are cost considerations for those claims. So there's now a new unfair contracts regime introduced by the new Closing Loopholes reforms. And essentially it confers new powers on the Fair Work Commission to consider and adjudicate unfair terms and service contracts. And those applications for an unfair contract application can either be brought by the party to a services contract, presumably the claim would only ever be made by the contractor rather than the principal. And if it's the party to the services contract, that is the contractor, they need to be earning less than the contractor high income threshold to bring that claim. If they don't, then they have to go through the independent contractors jurisdiction of the federal court. But an application could also be brought by an organisation that represents the party's industrial interests, and that could well be in the case of contracts of bailment or contracts of carriage, the industrial organisations and unions that deal with those contractors. Now, there's also another requirement that the terms of the service contract in dispute must relate specifically to a workplace relations matter. That is, a matter that would be relevant to an employment relationship if the employment parties were in fact in an employment relationship. If it's a purely commercial term, then arguably the Fair Work Commission wouldn't have jurisdiction to deal with whether that's an unfair contract term. In determining if a service contract term is unfair, the Fair Work Commission can take into account various criteria and conditions and circumstances. Firstly, whether the term imposes harsh, unjust or unreasonable requirements on a party, whether the term is reasonably necessary to protect the party's legitimate interests. This one's interesting. Whether the contract as a whole provides for a total remuneration that's below what workers doing the same work would receive per an award or enterprise agreement, or less than what employees receive who perform the same or similar work. In other words, if a business decides to engage someone as a contractor simply to undercut a modern award, that presumptively that would give rise to an unfair contract term and entitle that contractor to make a claim. Finally, the relevant bargaining power of the parties is a relevant consideration, including any significant imbalance between the parties' rights and obligations. Typically, when it comes to independent contractors, there is still a power imbalance, maybe not as pronounced as one between employer and employee, but it's typically the case that the principal has a significant proportion of the power in those relationships. So that's a relevant consideration too. So if a claim is made under the unfair contracts jurisdiction, the Fair Work Commission can deal with the application as it sees fit, including by conducting conferences or hearings. The Fair Work Commission, interestingly enough, can make a cost order against the party if and when appropriate, and that's rare for the Fair Work Commission to make cost orders. I think it's to mirror the fact that the unfair contractors jurisdiction under the federal courts has cost consideration. So they don't want to make it too difficult or make it seem like an easy option for contractors. And if the Fair Work Commission is satisfied a service contract contains an unfair term, it may either make a declaration that the terms are unfair, make an order setting aside all or part of the services contract, or they may amend or vary the terms of the contract in line with terms that would be fair if the parties were in an employment relationship. That's quite a significant degree of powers. Typically, declarations are powers that courts can only exercise. So the jurisdiction imposed by the new reforms, or the powers conferred by the new reforms, actually allows the Fair Work Commission to make declarations, which is a bit of an unusual one. It's also a bit unusual that the Fair Work Commission can amend or vary the terms of the contract. Typically, under common law, when there's a question about unreasonableness, for example, in the case of a dispute over whether post-employment restraints are enforceable, under common law, a court doesn't have the power to amend contracts. In New South Wales, the Supreme Court does have the power to do that, but that's expressly conferred by legislation. But specifically, the Closing Loopholes reforms specifically allow the Fair Work Commission to amend or vary the terms of the contract itself. Now, I'll finish off by discussing the same job, same pay protections. As I mentioned, these protections relate to labour hire. I noticed that when the legislation was first announced and there was the initial media attention about the same job, same pay protections, a lot of the media attention described it as relating to gender inequality provisions or a gender inequality protection provision. It's not that at all. It actually relates to, it's designed to plug what's called the labour hire loophole, which is essentially where host employers use labour hire, outsource labour hire to undercut bargain wages or conditions in enterprise agreements. So it's essentially a protection for those employees who are engaged or employed by labour hire companies, but apply the terms and conditions of the host employer that they work for, which is a bit unusual. Essentially, it's essentially a protection, or it's a provision that allows or requires an employer to match the host's terms and conditions for certain employees. In essence, it empowers the Fair Work Commission to make regulated labour hire arrangement orders that require labour hire employees to be paid no less than what they would be paid if employed directly by the host employer under the host employer's enterprise agreement or other instrument, and those are defined as the protected rate of pay. And obviously, the protected rate of pay is exactly what the employee would have been entitled to receive if employed directly under the enterprise agreement, including any monetary allowances, penalty rates, or incentive payments. So the power of the Fair Work Commission to make a regulated labour hire arrangement order exists when all of the following apply. Firstly, and I'm using the definitions in this slide. You'll see the definitions used in the provision, so I've included them for ease of reference. Firstly, the labour hire employer, described as the employer, supplies or will supply either directly or indirectly one or more workers, described as regulated employees, to perform work for a host employer, which is described as the regulated host. And secondly, the regulated employee will be covered by an enterprise agreement, described as the covered employment instrument, as between the regulated host and its other employees. And thirdly, the host employer is not a small business employer. In other words, none of these provisions apply if the host employer is a small business. I don't think that would be an issue so often in practice, because most of the time, firstly, small business employers don't outsource to labour hire companies, although I'm sure there are cases where it happens. But more importantly, because it relates to or requires the application or the reference to an enterprise agreement with the regulated host, it's very rare to find a small business covered by or having an enterprise agreement in place. So I don't think that would be a relevant consideration in most of the time. Now, who can apply for a regulated labour hire arrangement order? They can be sought by any of the following: either a regulated employee, so the employee who's the labour hire employee, the regulated host, the host employer, another employee of the regulated host, so someone who works alongside the labour hire employee, or a union entitled to represent the regulated employee or another employee of the regulated host. But you'll see who's missing from that list is the actual labour hire employer. Can't seek it. And that makes sense because they obviously wouldn't want to do that. The regulated labour hire arrangement orders can only be made in respect of national system employers and employees, which makes sense because this is the national system legislation. So the Fair Work Act, which is being amended by these reforms, by and large only covers national system employers and employees. But the regulated host can be any constitutional corporation, entity incorporated in state or territory, or an individual. So there's no real limitation to the form of the regulated host. It also appears that the regulated host can also be an entity that's incorporated outside of Australia, provided they're a constitutional corporation, or there's a subsidiary entity that's a constitutional corporation, and there's an enterprise agreement that covers them. Again, I don't think that would arise very often in practice. So mainly it would apply to most constitutional corporations who are the recipient or the beneficiary of labour hire services. Now, the Fair Work Commission can only make a regulated labour hire arrangement order if it's satisfied the performance of the work is for the supply of labour and not for the provision of a service. Now, what does that mean? That means that if you're essentially providing labour because you as an employer are providing a holistic service, for example, an IT service to a client, that probably wouldn't entitle a regulated worker, regulated employee to make a regulated labour hire arrangement order. It needs to be the supply of labour for the provision of employees to do work as the regulated host requires, if and when required. Now, to determine this, the relevant considerations include the involvement of the employer in matters relating to the performance of the work. That's what I just mentioned in relation to the specific example of an IT service provider, where they might make a consultant available for a client to do work on site, but that's generally as part of the service of the IT service provided by that entity. The extent to which the employer directs, supervises, or controls the regulated employee. The extent to which the regulated employees use the systems or plant of the employer. The extent to which the employer is subject to professional standards or responsibilities. I'm not sure how often that will apply in principle, because I don't think labour hire workers typically have professional standards that apply to them. And finally, whether the extent to which the work performed is specialist or expert in nature. And again, I think that harkens back to my example of the IT service provision, the IT expert provided by the service provider. Finally, the Fair Work Commission is required to only make a regulated labour hire arrangement order if it's fair and reasonable to do so in the circumstances. And it can take, in order to determine whether it's fair and reasonable, it must take into account any submissions made by a party in relation to any of the following. You'll see there existing pay arrangements that apply to the employees of the regulated host, the history of the industrial arrangements applying to the regulated host and the employer, the relationship between the regulated host and the employer, for example, if they're associated entities, the terms and the nature of the arrangement under which the work is performed, and any other matter that the Fair Work Commission considers relevant. And finally, if the Commission finds that it's not fair and reasonable to make a regulated labour hire arrangement order, they can order an alternative protected rate of pay, which is a lower rate of pay, but nevertheless a protected rate of pay, if it considers it's unreasonable to pay for the labour hire employer to pay the employees at a rate of pay that would apply if they were employed by the host. For example, the host just has more resources than the labour hire service provider. So these commencement dates for the same job, same pay protections, as I mentioned, the provisions commence on the 15th of December 2023. I think I mentioned that at the start with the timeline. Interestingly, however, any regulated labour hire arrangement order that's been made by the Fair Work Commission won't actually take effect until 1 November 2024. That means that parties who have jurisdiction to make those applications can make the applications and seek the orders now. And even if they are made before 1 November, they won't take effect until 1 November. When an application is made, the Fair Work Commission has the power to conciliate and arbitrate disputes about labour hire provisions, and they can resolve disputes over certain aspects of those issues, such as whether it's the correct rate of pay, and they can make an arbitrated protected rate of pay order after the arbitration process. Before any application is made about a dispute over a regulated labour hire arrangement order, parties have to attempt to resolve those issues in that dispute at the workplace level first. So I know that's a lot of information I've just thrown at you, and it's probably a bit of overload. The good news is that these slides will be made available to anyone who wants them after the presentation, so these will be distributed. But I thought I'd try and wrap it up very briefly by summarising what employers need to do. Obviously, it will depend largely on the nature of every employer's enterprise and their arrangements as to what they need to do. But in summary, the first thing that any employer should do is determine which the reforms will likely affect them and the relevant commencement dates. So So obviously, if you've got time to prepare, that's great. If there are reforms that are already come into force, then you'll need to make sure that either if you have, you're either complying with them, or if you haven't, the arrangements are made to start compliance or ensure compliance as soon as possible. Another thing that all employers will do, particularly those who employ a large cohort of casual employees, is to consider whether any of those casual employees are likely to satisfy the new definition of casual employment after the introduction of the new definition on the 26th of August. But again, fortunately noting that there's no automatic conversion to permanent, there's no automatic conversion regime, and the transitional provisions don't deem them to become permanent after after a period of time. Next thing that employers should do is to consider whether any engaged independent contractors or consultants are likely to be seen as employees under the new definition after 26 August. That means you should assess all the relevant factors. You also may know whether particular independent contractors are likely to dispute these aspects, or whether they are likely to just go along with the deemed independent contractor relationship. I think when it comes to independent contractors, if you are concerned about the potential shift of the definition and the increased likelihood that in the future, people who are engaged as independent contractors may be seen as employees or make claims that they are employees, a good way to deal with that is to engage them pursuant to a corporate vehicle that they own and operate, so that if there is an argument raised that the contractor or a consultant is an employee, well, they are the employee of their own entity. And you as the principal are kept out of harm's way as much as possible. You also need to prepare for increased administrative and compliance costs. So you'll need to, presumably, there'll be an expense involved in reviewing and analysing contracts, having them updated if required and as required, and ensuring that any arrangements put in place are defendable and enforceable, particularly in the case of independent contractor relationships. For those who use outsourced labour, consider the ongoing value versus risk of labour hire arrangements in case regulated labour hire arrangement orders are made. And for those employers who engage labour hire in order to avoid enterprise agreement terms and conditions, then that option will obviously shortly no longer be available to you, and that'll give rise to increased risk. You'll need to ensure that payroll systems, time recording, and pay rates are set up to avoid systemic underpayments. Now, even though I haven't covered it, the new reforms include the criminalisation of wage theft and super theft. So to avoid both corporate and potential personal liability for those types of claims, you'll need to make sure that you are complying with relevant minimum rates of pay under awards or enterprise agreements. Employers should also become familiar with the employer's obligations relating to employee right to disconnect, which we discussed at the start. And finally, I think that employers should get their employment lawyers on speed dial, because this is likely to cause a bit of unrest and upheaval certainly over the next 12 months. And for the things that we've been discussing today, certainly after August 2024. I want to finish off by outlining that Matthews Folbigg is prepared to make a special offer to viewers and participants to our presentation today, to offer an employment health check. That provides that for a fixed fee of $9.90, inclusive of GST, Matthews Folbigg will review up to 3 pro forma employment or contract agreements and provide observations about those agreements in relation to various things we've been discussing today, as well as potential contraventions of the Fair Work Act or applicable modern award, as well as potential inadequacies about those commercial terms such as confidential information, intellectual property, or restrictive covenants. And once those observations have been provided, then we can certainly update or redraft those agreements as required for a separate fee. And obviously, we can provide fee estimates for that work following the observations. That offer is available for all viewers up until the 31st of July. And if anyone wishes to take that up, please feel free to contact myself or any member of the Workplace Solutions Employment Law team at Matthews Folbigg, and we'll be happy to start the work as soon as possible. That is all I have to cover today. I know there was a lot. I'm glad we managed to get it within the hour without, whilst doing justice to most of the topics. If there's any questions, time permitting, I'm happy to cover them off now.
Thank you, Peter, for such an informative presentation. We will run over a little bit just for those of you that have questions. So if anyone has anything they'd like to ask Peter, please enter it into the Q&A box below. And I did notice that we do already have some questions, Peter. So the first question was, what's the difference between a RLHAO and an EOR?
EOR. Okay, I actually don't know what an
employer of record.
Employer of record. Okay. That's a good question. I actually, if employer of record is a reference to the new legislation, I'm not sure where it is. I'll probably need to take that one on notice and come back to that questioner. Yeah, because obviously there's a technical difference and distinction that relating to the terminology I'm not aware of. So let me take that one on notice. Sure. Obviously, the regulated labour hire arrangement orders are a specific definition, and that's the definition used in the new reforms.
Thanks, Peter. And then there was another question here that asks why you stipulate admin staff in law, not all, when discussing the new employee right to disconnect. My understanding is it covers all employees.
Oh, yes. Okay. So because the right to disconnect relates to the reasonableness of the employer to request or to contact employees out of hours, the assessment of reasonableness will depend on all the circumstances of the employment relationship. And even though it does cover all employers, regardless whether they're covered by an award or an enterprise agreement, whether the reasonableness of the requirement to respond to out-of-hours contact may be increased or more relevant for certain industries or professions. So you would see that, for example, a legal admin employee may be required to read, respond, or monitor out-of-hours correspondence. So they would be covered by the legal services award. They may be required to respond to out-of-hours correspondence if preparing for a hearing or requiring assistance for preparing for a hearing or other legal proceeding. It really depends on the circumstances of the request, but I would say that those sort of employees would have an increased obligation to respond to those queries, whereas let's think of another one. A retail employee would be less, it may be less necessary or reasonable to respond to out-of-hours contact if it's a retail employee working a permanent regular shift. So they're not typically expected or required to fill in replacement shifts if people are away. So it depends on the nature of the work involved, the nature of the duties and responsibilities. But I would certainly say that, speaking for myself, if there's an upcoming court hearing coming up, it would be reasonable to expect that all hands on deck in the days leading up to that court hearing. And so legal admin staff may have an increased obligation to respond to out-of-hours contact, as long as it's not unreasonably too far out of hours, of course. It might be, within the hour after the typical day ends, or, late on on the Sunday, not too late before the hearing on a Monday, for example.
Sure. I will also just note to everyone that's still online that if there are any questions that are not answered for you today, that you can email them through directly to Peter or to WSBC, and we'll have them answered as well. But I do have two more questions here, Peter, if you have time to answer them.
Sure, yeah.
Does a contractor change if they're being paid super?
Yes, so that's a question that's often raised by clients and certainly employers that seek advice as to their obligations for their contractors. Superannuation is a statutory entitlement to workers, and it's not limited specifically to employees in the traditional sense. So it applies to, it expands the definition of it has an expanded definition of worker, and provides that any worker who's wholly or principally engaged for the provision of labour are entitled to superannuation contributions on their ordinary time earnings. And so that expanded definition obviously covers employees, but expands beyond employees to independent contractors and consultants who are engaged on an individual basis. The good news is for those contractors who are essentially a key person to a tripartite contract between the principal, a corporate vehicle operated by the contractor individual, and the individual themselves, any obligation to pay super would be between the key person and their own corporate vehicle. So yes, there is an obligation to pay super for contractors wholly or principally engaged for the provision of labour, but there are ways around that. You obviously don't have to pay superannuation as a principal. You don't have to pay superannuation to a corporation. So it only apply if you're engaging a particular individual.
Okay. And just whilst we're on that topic, we have a question here from Sarah asking if the contractor is from a company, trustee, truster or partnership, would it be regarded as a contractor or an employee?
It would be far more likely, overwhelmingly likely, that they would be the entity itself, the company or the trust or the partnership would be the company in particular would be the contractor, and the person who operates that entity would be a third party, which we would describe as the key person. So typically we recommend two potential approaches for contractor relationships. There's one between what we describe as the principal or the company and the key person. Sorry, the principal and the contractor, or the principal, the contractor, which is the company in this particular case, and the key person, who is the person at the coal mine doing all the work. But that person owns and operates the company. So yes, in the particular case of the question, if that person, I wouldn't call them the contractor because I'd say the company is the contractor. The person who's owns and operates that company would be the key person rather than the contractor.
Okay.
And the terms of the contract would apply obligations only between the principal and the contractor. But you can then bind the key person to certain additional obligations, such as confidentiality.
Okay. Thank you very much, Peter. We have another question here asking if there is a template of an employee agreement available.
Certainly, yes. So we have, our approach is that we have a very rough structure for employment agreements and contract agreements that we tailor in each particular case to clients that require them. So we usually we get some information as to what the requirements are, whether there's particular terms and conditions that they use, whether there's an existing contract that's been used that they want to either modify or update or preserve certain terms for. But then we use our own pro forma templates as a base and then superimpose the specific requirements so they're customized for the client. Obviously, our pro forma templates are refined from time to time. So whenever there's changes in the law, decisions that may affect the interpretation of contracts, we update them on each of those occasions. So they're as up to date as they possibly can be. Yeah. And if any clients or customers, if any of our clients use our templates, then it's a simple process of updating them, 3 or 4 years down the line when it's time for a contract review, because essentially we just apply our most recent templates and then superimpose the changes.
Sure. Is that template something that you would be happy to share with the person asking a question, regardless of whether they are a client of yours or they would need to be a client?
They would need to be a client, unfortunately, because they're so specialised. There's several hours worth of work involved in that.
Sure.
And unlike a lot of those service providers that have a template or a system on the websites that allow you to insert details,
Yeah.
Ours are far more comprehensive than the typical Fair Work Commission or insert your own terms templates that you see. So it is a professional product, and so we can make them available, but there is a fee involved in doing that.
Sure. Thank you very much.
Yeah.
Now, just further to the question regarding super, there's a question here saying that this organisation has a contractor. He's a sole trader.
Yep.
And he chooses to be a contractor, but they pay super.
Yes.
Do they need to be worried about these changes?
I wouldn't say in and of itself, the mere fact of paying super isn't determinative of an employment relationship, because, as I mentioned a few moments ago, the superannuation legislation deems sole trader contractors who are engaged wholly or principally for provisional labour to be entitled to super. So that employer who asked the question is actually doing the right thing. They are required to pay super for sole trader contractors. Presumably they are engaged wholly or principally for the provisional labour rather than a particular project. But it would depend on the other circumstances of the engagement, whether there's whether the sole trader contractor has the right to do work, accept work when they attend for work, or whether they can delegate the work, whether they provide their own equipment and plant. So all those other factors that were mentioned earlier are the relevant factors, whether they're employees or independent contractors. We can certainly advise them about this particular example, but just the sole fact that they receive super isn't at all determinative of whether they could potentially be an employee.
Okay, thank you very much, Peter. Now that addresses all of the questions that are in the Q&A box. So I might go ahead and wrap us up for this morning or this afternoon now. So that concludes our session for today. Thanks again, Peter, for your time, and Matthew's Folbigg Lawyers for supporting this webinar.
Thank you.
Please remember that our Open Leadership Accelerator program is starting soon and consists of 6 live half-day sessions. If you've promoted high-performing individuals to team leaders and supervisor roles, only to find that they're just average as a leader, this program is for you. It'll equip them with the 5 essential skills they need to become genuine and successful leaders. Find out more about this program on our website or contact myself or Cassidy. I will also mention that we have a special offer running until the end of the month, offering 10% off membership to new, returning and existing members if you pay before the end of June. And finally, I would also like to thank you, our members and our guests, for attending today and your ongoing support. Have a great afternoon, everyone.
Thank you.
Thanks, Peter.
Thanks.
Bye now.